What kind of contract do you need to have in order to buy or sell a business? My name is Peter Hanna. I'm with the law firm of Hopler, Wilms & Hanna. I'm a business attorney who works with clients to determine just that question, as well as developing and drafting those contracts. Before we answer that question with our clients, we ask the big question of, has there been an initial negotiation with the other party for the purchase or sale of the business? Has that initial negotiation been set in stone through a written document such as a letter of intent or a term of agreement? Letters of intent or terms of agreement typically will establish the most basic level discussions, such as how much are we selling the business for? How long does the buyer have in terms of due diligence to complete an investigation of the seller's assets to ensure that this is a good deal? And then finally, what type of structure will the buyer and seller utilize to ensure a smooth and final transaction? Typically, when we think about a structure of a transaction, we are talking about something called a definitive agreement. In today's video, we're going to be talking about definitive agreements and why they are so important. Definitive agreements discuss, again, the definitive terms and conditions finally agreed to by buyer and seller. Typically, when we're thinking about a purchase of a company, or I should say a purchase of a business, that can be a lengthy period of time. This could be a period of, up to between 30 and 90 days for the most straightforward of businesses, or up to a year. And it's during that time that several terms and conditions can crop up, and we need to eventually put that into writing. So we do that through the form of a definitive contract. A definitive agreement will also establish, among other things, what types of assets are being sold in the business. Are we selling stock, membership interest, or intangible and tangible assets? We're also discussing in a definitive agreement the purchase price and the structure of the purchase price. Will the buyer be required to place an escrow deposit? Will the buyer have placed any amount in escrow for a certain period of time that encapsulates certain terms and conditions? Do we need to allocate or create an asset allocation for Internal Revenue Service purposes? That's typically what's discussed in the purchase price portion of the definitive agreement. We're also talking about liabilities. What are the types of liabilities that buyer will be handed off at the time of closing? And what types of liabilities will the seller maintain at the time of closing? What kind of promises, representations, and warranties are the parties making to each other at the time of closing? Does the seller make a promise that they have been truthful and accurate with regard to diligence items that have been presented in terms of the representations that he or she has made to the buyer? We would hope so, but those are things that are discussed in a definitive agreement. We also talk about transition. What type of expectations does the buyer have of the seller to remain on staff or to assist the buyer with a smooth transition after the closing is completed? What do those terms and conditions look like? These are all things that are established in a definitive agreement. Typically, we work with our clients to develop one of three different types of definitive agreements. One is a stock purchase agreement. That's where a corporation in Inc. is selling its shares to the buyer. The buyer is stepping into the shoes of the seller. The other is a membership interest purchase agreement, and that's where a seller is selling its LLC membership interest to a buyer. And then the third most common and most recommended type of definitive agreement is an asset purchase agreement. And that is where seller entity is selling to buyer's entity certain assets. Definitive agreements are incredibly important to a deal because every deal is different. Every business is different and unique, and therefore its terms and conditions for sale are going to be unique. And so buyer and seller will work through legal counsel to ensure that those terms and conditions are clear, concise, and agreed to by both parties. And it is only when that has occurred can we come to a closing and really have a meeting of the minds. Definitive agreements take into account all the nuts and bolts, all of the moving parts that are involved with the sale of a transaction, which is incredibly important. And without a good definitive agreement, we can't have a good sale of the business. I love talking to my clients about every aspect of a business deal, but when it comes to the contract portion of it, this is where you need an experienced attorney to assist you in this process. If you'd like to speak to me about the business transaction process, especially the definitive agreement process, I'd be happy to provide you with a free consultation to talk about the nuts and bolts of the business transaction, and we can go from there. Love to talk to you. My name is Peter Hanna. I'm with Hopler, Williams & Hanna. Thank you.